Good morning. My name is Dana Berliner, and I am the litigation director at the Institute for Justice. Today, the Macedonia Missionary Baptist Church and many homeowners and a business owner in Ocean Springs all appeared before the Fifth Circuit Court of Appeals to argue that the city of Ocean Springs violated their constitutional right to due process when the city designated their neighborhood as a slum. It failed to tell them about it, and in particular, it failed to tell them about their 10-day period to challenge that designation. There are only 10 days, and that is a defense against eminent domain, but no one told them about it. And so what we argued about today was whether that matters, whether they're entitled to notice and an opportunity to be heard on whether their neighborhood is a slum and blighted. The state and the city conceded that by the time you get to eminent domain, you are not allowed to say the area is not slum and blighted. And our position is, if you've only got 10 days in which to make that argument, there's got to be notice. We hope very much that the court will accept that argument. Greg?
Hi, my name is Greg Gibson. I'm the chairman of the Finance Committee for Macedonia Missionary Baptist Church. And absolutely, we're thankful for the Institute of Justice for taking on this case because without them, without this coalition that we formed, we shall not be moved. It wouldn't have been possible. And again, without notice, we were not notified that our area was blighted and slum, and we should have been notified, and we passed that 10-day window. And what came out of this was a group that we call We Shall Not Be Moved and formed a grassroots movement to be able to put this coalition together to help residents to advocate on their behalf as well as Macedonia Missionary Baptist Church behalf. And so with that, I am pleased and prayerful that the three judges will make a decision that is going to be hopefully that the state of Mississippi send them a message to let them know that residents as well as homeowners should be allowed to be notified under these circumstances. Thank you.
Good morning. My name is Faye Payton. I am a property owner in the city of Ocean Springs, Mississippi. I am very pleased with what we heard on today from the judges. It seems positive. There are some changes needed within the state of Mississippi, not just within the city of Ocean Springs. Anyone is deemed or to be required to be informed of changes as it relates to their property. No one wants to be caught off guard, and especially if your property is being deemed slum or blight and you have a 10-day window to take action. That is not fair, and especially if you are not informed by letter. We all need to make a change. The state of Mississippi needs to make a change for all of its residents. Everyone, we are human beings and we count. We need to be heard. Thank you.
Good morning. My name is Leah Campbell. I'm founding president of an organization called Mississippi Rising Coalition. We're a statewide advocacy group that advocates on behalf of economic justice issues. We are here today to stand in steadfast solidarity with the impacted residents of Ocean Springs, but we feel it's really, really important to underscore what Faye said, that this is not just an issue impacting Ocean Springs residents. It could have and has had impacts statewide. If a local government can declare a property slum and blight in Ocean Springs, they can do the same thing elsewhere across the state, and this has deep impacts on families and businesses throughout the state. We do hope that the Fifth Circuit will understand the merits that the attorneys with Institute for Justice argued today, and remedy this for the state of Mississippi. And we'll continue to stand with the residents of Ocean Springs.
Tina, do you want to take any questions?
Sure. And I should add, there are, in Jackson, in Biloxi, there are numerous existing slum and blight designations. They're permanent in Mississippi. So unless the city gets rid of them, they just last forever. And everyone in those areas has already lost their opportunity to challenge them. So this is something that impacts people right now in Mississippi, and it will impact people in the future. Yes.
So what do you see happen? What do you hope comes out of what happened today in the Fifth Circuit? And what do you see happening if no change is made to this law?
So what we hope will happen is that the judges will reverse the dismissal of the case, say that there is indeed a due process problem here, that the law entitles them to notice, and then they'll send it back to the district court to fashion a remedy, which I think will be a declaration that this is unconstitutional and that the plaintiffs are entitled to $1. That will then cause the Mississippi legislature to change the law, which is what happened in Colorado and what happened in New York when people won similar cases there. If nothing is done, then cities across Mississippi will continue to designate areas slum and blighted. They won't tell anybody about it because Mississippi law does not require them to tell anybody about it. And then everyone will lose their rights without ever finding out about it. The only way now for people to realize that their rights are in danger is to carefully comb their city's website every single week to see if somewhere there is some mention that has something to do with urban renewal, blight, slum, a mention of chapter 4335. They just have to look and hope that they find that because there's no individual notice. And what's happening now in Ocean Springs is that somebody's got to be designated every single week to check because there won't be notice, and that is the only way for people to protect their rights. We've got a due process clause, and that's so people don't have to do that, and the government actually tells you when it is doing something that will violate your rights.
Would you take this up with the Supreme Court if it went the wrong way?
So if the Fifth Circuit rules against the church and the other owners here, it will be disagreeing with two other federal circuits, the 2nd and the 10th. And that is often a basis for the Supreme Court to take a case.
Where do you think that would go if it get that far?
If we lose, we would certainly ask the Supreme Court to review it, and I think we would win because the case law is really clear that people should get notice. And notice, by the way, it's not like notice is really hard. They need to send a letter. This is not some unbelievably onerous burden upon cities. If they're going to do a slum and blight designation, they need to send a letter to people in the area. That should not kill them.